Deed. Section 122 of Transfer of Property Act defines gifts, and it is gift is the transfer of certain existing movable or immovable property and not of future property. It must be voluntary. It should not be induced by coercion, undue influence, fraud, or misrepresentation. It should be without consideration. It can be for natural love and affection or for past consideration. It cannot be for natural love and affection or for past consideration if cannot be for present or future consideration. It must be accepted by the donee. It may be pointed out that the definition of gift in the Gift Tax Act 1958 includes a transfer for inadequate consideration, a release, a discharge, and surrender, but this definition is for the purpose of gift tax only. It's under Hindu law. So, the right given and the restrictions imposed by Hindu law in respect of powers of Hindu to make a gift still apply, but the mode of making a gift is governed by the provisions of Chapter 7th of the Transfer of Property Act. Thus, a gift by a Hindu of his separate and self acquired immovable property can only be made in the manner prescribed by Section 123 of the Transfer of Property Act, and it has to be accepted by the donee. Gift under Mohammedan law. So, the Mohammedan law of gifts is affected by the provisions of the Transfer of Property Act, since Mohammedan law permits an oral gift even with respect to a gift of immovable property. A registered instrument is not necessary for such a gift by a Mohammedan. Under Mohammedan law, the essentials of a gift are a declaration of gift by the donor, the acceptance of the gift by the donee, and delivery of possession such as the subject of the gift is susceptible of even a registered deed or gift is ineffectual. Under Mohammedan law, it is not accompanied by deliver of possession. Under Mohammedan law, a Mohammedan can make a valid gift to a Hindu or any other person, and such a gift is governed by the law of donor. How made? The mode of making gifts is prescribed by Section 123 of Transfer of Property and can only be made by a written instrument signed by the donor, attested by at least two attested. A gift of movable property may be made either by a written, attested, and registered document or by delivery of the property to the donee. It is permissible to make conditional gifts. The donor and the donee may agree that on the happening of any specified event which does not depend on the will of he donor, a gift shall stand revoked. A gift which the parties agree shall be revocable at the will of the donor. A gift can be made which is effective only during the lifetime of the donor. A donor can reserve a right in himself for life to take the profits of property gifted, or he may also, while making an outright gift, impose a condition that the donee shall maintain him. A gift may also be made for a specific purpose, and on the failure of that purpose, the property reverts to the donor. Now, revocation of gifts. So, a gift once duly made and accepted cannot be revoked. A conditional gift which provides that it shall stand revoked on happening of a specified event which does not depend on the will of a donor is revoked when that event happens. A gift may also be revoked if it has been obtained by coercion, undue influence, fraud, or misrepresentation. A gift for specific purpose can be revoked on the failure of that purpose. Stamp duty. An instrument of gift is chargeable with stamp duty under Article 33 of Schedule 1 of the Stamp Act. The duty is the same as is payable on a conveyance, which is for a consideration equal to the value of the gifted property. A conveyance is charged under Article 23.